Ladies and gentlemen, we begin this second session together literally in the midst of the second of what I've identified as 6 possible issues of contract law that could confront you on the California bar exam. In our first session, we found the elements of agreement, and we concluded that session by raising the second question or issue. If you have found a private agreement, does it qualify for the legal status of a contractual relationship? We saw that that was dependent essentially on identifying the elements of bargain, and within the element of bargain on both sides of the exchange, the incursion of what we called legal detriment. Suppose that we cannot find legal detriment on the part of one of the traders, and we cannot imply it, and the subsequent conduct of the traders does not cure the want of consideration. Then there is no contractual relationship. But we would now pass to the third aspect of developing this second issue, because there may be liability for breach of a promise given in the fact pattern, not on a theory that it is breached a contract, but on a theory of promissory estoppel. This is the significant substitute for valuable consideration in rendering a breached promise actionable at law. Now here is a technical point, but it may help sort out your understanding of promissory estoppel and the law of remedies. If the plaintiff brings his cause of action on a theory of promissory estoppel, it is not a contract claim. Promissory estoppel is a separate civil law theory of liability for breach of promise. It is an alternative to a contract or contractual analysis. Now, the key to understanding the doctrine of promissory estoppel is that as a result of a promise that has been breached, the promisee, the individual to whom the promise was made, alleges that he is now unjustly impoverished, literally worse off than he was before the promise was ever made to him. Unlike the restitution interest, which will be reviewed in your remedies materials, and which is protected in an action in quasi-contract, to recover on a theory of promissory estoppel, it is not necessary for the plaintiff to show that the defendant has been unjustly enriched, merely that the plaintiff has been unjustly impoverished. So the promissory estoppel action protects what is called the reliance interests of the aggrieved party. What are the elements of a cause of action in promissory estoppel? Well, here's one area where the terminology of the law tells the essence of the tale. First, we must locate in the fact pattern a promise made by one of the parties to another individual in that fact pattern. But here's the point. That promise must have had the foreseeable quality of inducing reliance on the part of the individual to whom the promise was made. So it isn't sufficient to find just a promise. You must qualify the promise as having had this quality of the foreseeable consequence of inducing reliance. The next element, in fact, the promise must have occasioned reliance on the part of the promisee, which could either be in the form of actions taken by the promisee or actions forborne. But these actions must have been in reasonable expectation that the promise would be kept. So the second element is detrimental reliance by the promisee. The third element, rather obvious, is a breach of promise by the promisor. And the fourth element derives from the first three. As a result of that breach, and as a result of the reliance acts, the promisee is now aggrieved, worse off. If all four of those elements are present, Section 90 of the restatement bids a reviewing court to hold the breaching promisor bound to the terms of her promise, at least to the point necessary to allow the aggrieved party to recoup his reliance interest. Now, the initial tendency was to use the doctrine of promissory estoppel to remedy promises that were gratuitous in nature, half-completed gifts. But recent case law has been extending the doctrine of promissory estoppel into the business world. And today, you could develop quite an intriguing specialization in the practice of law, representing individuals in the franchise world, where they are normally protected on a theory of promissory estoppel. Let me give you an example that will illustrate the doctrine in its business application. You will recall in our first session that we had, from my perspective, a tragic future experience in which you acquired for a gossamer $500 the fabled and long-lost Bakersfield Botticelli, a masterpiece worth millions if one could put a price on it at all. Well, as the songline goes, good for you, but what about me? Well, the facts will reveal that I couldn't live in Bakersfield after that episode. I couldn't stand the taunts of children who'd follow me on the streets calling me the boob of Bakersfield. And so I was forced to remove myself from that community. My bride and I have sunk deeper into the deserts of Southern California. We've taken up residence in Barstow, California. Barstow turns out to be our kind of town, a sleepy little village where you go to the local gourmet food store to buy Velveeta cheese. One day I'm walking down Main Street of Barstow, California, when I spot an elderly gentleman wearing a white suit and a Panama hat. I may be a boob, but I'm no fool. I recognize Colonel Harlan Sanders. I pour out this tale of woe and tragedy in my life to the Colonel, and moved by compassion, the Colonel promises that he will grant me a franchise to prepare and market right there in Barstow that finger-licking product. Now notice there has been no bargain. The Colonel has simply made a promise. But now what happens? Well, in reliance upon the Colonel's promise, I undertake the following. At my own expense, I enroll in a course in chickenology at Fowle University, learning to prepare the product according to the Colonel's most closely guarded recipe. My wife and I also take what we've been able to salvage from the antique business in Bakersfield and plow it into the remodeling of a structure in downtown Barstow, which will function as our place of business. And finally, since tragically I've not been able to get the children out of the house yet, I convert my spouse and children into individuals who are seized sort of a foul fetish. They will not eat anything other than chicken. In the meantime, they sit around all day and suck their fingers. Now, friends, brace yourself, because here comes tragedy. In the wake of all of this reliance on my part, the Colonel changes his mind and breaches his promise. Could I bring an action against the Colonel for a loss of bargain recovery of money damages at law? Not at all. You see, there was no contract. There wasn't an offer. Therefore, the element of bargain was missing. And consequently, there could be no contractual relationship. But it is abundantly clear that the Colonel did make a promise. It is also clear that I'm worse off today than before I met him. Is there anything the law can do for me? Well, I may be able to qualify for recovery on a theory of promissory estoppel. Now watch what I must prove. First, I must establish that the Colonel is guilty of a promise which on the day he made it to a reasonable person had the foreseeable consequence of inducing reliance on the part of the promisee. If I can establish that, the next element of my cause of action is to show that I changed position in detrimental reliance upon the Colonel's promise. And finally, I must establish a breach of the promise, very clear. And next, I must seek a recovery of such damages as are necessary to put me back to the position I was in on the day the Colonel made the promise. Well, I will gain some relief, but not everything, because let's walk through the analysis. Would a reasonable person in the Colonel's position have seen that in order to take advantage of his promise that I would be given a franchise to operate a Harlan Sanders chicken palace in Barstow, have foreseen that I would have to take steps to learn to prepare the food? The answer would appear to be yes. The steps that I took were also reasonable. They were within the ambit of what was foreseeable. And I will recover the cost of tuition at Fowle University. Any expenses I incurred in leaving my home and taking up temporary residence there may all be shifted as elements of loss to the Colonel on a theory of promissory estoppel. What about the fact that my wife and I have sunk the diminished family fortune into the construction or remodeling of a chicken palace in downtown Barstow? Well, again, the question is, was that foreseeable to a reasonable person? Certainly it would be foreseeable that some structure would be required Assuming that our structure is within the realm of the reasonable, we would appear to be able to shift the incidence of cost to the kernel, but we won't get all of our costs, just enough to allow us to remodel the structure for some other economic use. This is definitely a consolation prize compared to remedies for breach of contract. The third may be my most impressive dollar claim, and that would be the sum $75,000 to $100,000 I'm going to have to spend on the psychiatric rehabilitation of my loved ones. Right? Now, the issue would be, was that type of reliance within the realm of what was reasonably foreseeable? I fear the answer will be no, and I would recover nothing on that aspect of my claim. So to recover on a theory of promissory estoppel, the object of the law is not to put me in the position I would have been in had the promise been kept. It is the far more conservative agenda of putting me back where I was before the promise was given. But it only protects those reliance costs which were foreseeable as a consequence of the promise and which were reasonable on my part. Now, a couple of things to notice. Since promissory estoppel is not a contract claim, the action is not affected by the statute of frauds. The fact that the colonel's promise was oral is no problem at all. I'm not recovering a contract remedy, merely promissory estoppel, which does not fall within the statute of frauds. Finally, if in the case of a promise to convey real estate, which is oral, which has induced the promisee to go on the real property and to make alterations of a substantial and permanent nature, promissory estoppel has been held by modern courts as sufficient basis to grant a decree of specific performance, quieting title in the promisee, because in this instance there is no reasonable way to measure and award reliance money damages. So that's all I want you to think about on the bar exam. If you encounter a fact pattern where there is no legal detriment on one side and therefore could not be a contractual relationship, and yet there has been a promise given, a promise breached, and in the facts it is evident that the promisee is now worse off than he was on the day before the promise was made, do an analysis of a potential recovery in promissory estoppel. This brings us to the fourth and last aspect of developing the second issue of contract law. For I said that if you had found a bargain, and you would look to the terms of that exchange, and you had found in the exchange of promises in the bilateral bargain that each party incurred legal detriment, each promised the other to do some act which but for this bargain there was no legal obligation to perform, or to forbear some conduct which but for this bargain the parties were legally privileged to pursue. If you found bargained for legal detriment, you are prepared to say that we have an executory bilateral contract. But before you are comfortable with that conclusion, the fourth step of your analysis is to take one last look at the facts to determine whether there are any defenses. Right? Now, defenses are of two types at common law. There are the so-called real defenses, which, if established, preclude the formation of a contract. They are few in number, but exceedingly powerful. One would be the obvious quality of illegality in the bargain. The offeror has dialed M for murder. A real defense is any defense which precludes formation of the contract. Far more common and numerous are what are termed personal defenses. These defenses admit that a contract was formed, but if established by the party who can avail himself of the defense, render his contract duties voidable. Now, those are the two types of defenses. What is my suggested approach to this topic? Well, when it comes to defenses, I suggest that you look for them under four categories. First are defenses that are related to the form of the bargain. Second category of defenses center on a problem with the capacity of one of the parties to the bargain. The third category of defenses focus on the content of the bargain. And the fourth category on the tactics of one of the traders in forming the bargain. Those are the four major concepts under which defenses can be organized. Let's briefly review them. Defenses rooted in the form of the contract essentially are talking about the statute of frauds, that it is an oral bargain when the law requires as a price tag for a remedy that it be in writing. Defenses rooted in the capacity of the traders are concerned with such things as that one of the traders was a minor or lacked the requisite mental capacity. In a crossover question into the world of corporations, we would also have the defense of ultra-virus or ultra-virus activity beyond the power of the corporate entity, the capacity of one of the traders. The third, defense is centered on some serious social objection to the content of the bargain. If the problem is a social objection to the content, we're talking about illegality or substantive unconscionability. And fourth and finally, defenses which are focused on the offensive formation tactics of the traders. Here we would briefly recall fraud, constructive fraud, duress, and overreaching. Right. Now that's a brief overview. Let's take them one at a time. When we speak of defenses that are centered on the form of the bargain, there's really only one, and that is the most common defense on the bar examination: the statute of frauds. As a general proposition, neither the common law nor the Uniform Commercial Code impose any mandatory form on the bargain. Contracts can be, and many are, oral in form. Oral contracts are perfectly valid. But the factor may present a problem in litigation if the subject matter of the oral bargain falls within the statute of frauds. Because if the subject matter falls within one of the categories under the statute of frauds, if there is no written memorandum of essential terms, then there can be no remedy at law recovering damages for breach of that contract. Unless, here's a major exception, unless the result of allowing the defendant to invoke the statute of frauds would be gross injustice, in which case a modern court will equitably stop the defendant from hiding behind the statute of frauds. How do you work with the statute of frauds in the bar exam? You begin by being aware of the basic subjects which, if they are the subject matter of the attempted bargain, fall within the statute. What are the important ones to remember on the exam? If the subject matter of the attempted exchange is real property, land, or any fixture permanently attached to the land, the agreement falls within the statute of frauds. Contracts for the sale of goods fall within the statute of frauds if their price is $500 or more. But there are exceptions. Under the Uniform Commercial Code, an oral contract for the sale of goods is perfectly enforceable to the extent that the seller has delivered the goods to the buyer and the buyer has accepted delivery. The seller's oral promise to pay $50 million for the goods that have been tendered and accepted is perfectly binding. The next exception under the Uniform Commercial Code, if both of the traders are merchants, a written confirmation of the terms of the bargain sent by one merchant trader to the other operates to satisfy the statute of frauds both as to the sender and the recipient, unless the recipient objects to its content promptly. And the third exception, where notwithstanding the fact that the price of the goods exceeds $500, an oral bargain for their purchase and sale will be enforced, obtains for what the code calls special goods. These are goods custom tailored or manufactured to the specific buyer's order or specification and not suitable for ordinary resale. To the extent that the fabricating seller has actually begun to fabricate, to manufacture those goods, the buyer's oral promise to pay for them is totally enforceable. Obviously, the reason is clearly spelled out in the nature of the exception. If the goods are not suitable for ordinary resale, if this particular buyer can hide behind the statute of frauds and evade liability on her oral promise to purchase them, we've got a hell of a lot of economic waste. So, two subject matters so far: real estate or any interest in real estate, goods if the price exceeds $500 or more. The third important category falling within the statute of frauds, showing up repeatedly on the bar exam: any contract which by its terms is incapable of being performed within 1 year. Within 1 year. But again, there's a little catch. If there is any possibility, no matter how statistically remote, right, how improbable, that the contract obligations could be fully performed within a year, the subject matter was never within the statute of frauds, though in actual experience it takes 50 years to carry out the terms of the bargain. An example: suppose that you were to come to my rescue and make a promise to support my youngest child, my 3-year-old daughter, with a $10,000 payment for the rest of her life. That oral promise is not within the statute of frauds, because God forbid my daughter might die before attaining her 4th birthday. And although the mortality tables suggest that the chance of that happening is less than 1 in 500,000, since there is the statistical chance, possibility, that you could fully perform on that promise within a year, it was not within the statute, and as she is qualifying for Social Security, you would still be obligated to make the promised payments. Right? Now, those are the subject matters that are important on the bar exam. What's the consequence of having one of those subject matters pertain to this particular transaction? If the subject matter of the attempted exchange falls within the statute of frauds, then the statute requires what is termed a memorandum of essential terms, quote, signed by the party to be charged, close quote. Now, please, I beg you, do not confuse the writing which will satisfy the statute of frauds with the formal, integrated instrument that we saw in our first session attract the protection of the parallel evidence rule. They have nothing in common. All that is required to satisfy the statute of frauds is written evidence of the essential terms. The writing, therefore, can be very informal. It does not have to have been created with any intent to satisfy the statute. We're looking for evidence of terms, not intention. If, through written evidence, we can reconstruct the essential terms, that evidence must relate to the party to be charged. The old formulation was that it had to be signed by the party to be charged. That, too, is less than it might appear. There doesn't have to be a formal signature. A printed letterhead would be quite sufficient, thank you. Many cases have held that a rubber stamp would suffice, and emphatically in modern litigation, a fax transmission would be sufficient. All we have to have is some means of tracing that written evidence back to the defendant. Why don't we insist that the writing also be signed by the plaintiff? Right? It only need bear the signature or authentication of the party to be charged. I wondered about that for years until it dawned on me. The plaintiff satisfies the statute of frauds with respect to the terms of the bargain when she files her complaint, which allege the terms of the contract and bear her signature or that of her attorney as her agent. Hence, the law only required the signature of the defendant. Right? So any writing, so long, it could be a series of writings that are stapled together or relate to one another by reference, any writing or writings from which the court can reconstruct the essential terms of the bargain are sufficient. What if that cannot be done? Then the defendant, whose written memorandum is missing, can avail herself of a personal defense. The contract is not void, but her obligations are voidable. Since it is a personal defense, we now cross over into the world of civil procedure. It will arise only if it is asserted in a timely manner. If the defendant fails to assert the defense in a timely manner, the defense is waived. As I told you a moment ago, it is now subject to the doctrine of equitable estoppel. Before the court will permit the defendant to create the defense, it will examine the consequence. And if the consequence would be gross injustice, the defendant will be forbidden on policy grounds to hide behind the statute of frauds. But if there is a timely assertion of the defense and the defendant is not equitably estopped, then there can be no recovery of damages at law. No recovery of damages at law. But here comes the interesting area in which we now move into the world of remedies. That means that the aggrieved party plaintiff has no adequate remedy at law, therefore has standing to sue in equity. Equity courts are not historically bound by the statute for frauds. And the consequence of that is that equity courts are willing to regard part performance of the terms of the oral contract as an evidentiary substitute for the missing writing. So long as the performance points to the contract which the plaintiff is alleging and not to a nebulous sum arrangement, there may well be equitable relief in the form of a decree of specific performance or injunctive relief. And finally, just to note one other time, if the cause of action is predicated upon a theory of promissory estoppel, the statute of frauds has no application at all, since that's not a contract claim. Right? The statute of frauds. It is rooted in the form of the bargain. Let's now speak of the capacity of the traders. If you were to reconstruct former California bar exams, you'll find that they ask two questions, or two types of questions that raise this issue. First, where one of the traders is a minor, we now have a problem, because under the common law, the contract obligations of minors are voidable. Yet their promises do amount to valuable consideration, because the law says so. The bargain is not void, and if the minor does not assert the defense, he is deemed to have waived it. But if in litigation the minor asserts the affirmative defense that he was under the age of legal consent on the day the contract was formed, there can be no recovery under the terms of that contract by the adult. But if the minor has consumed the benefits of the contract, and those benefits are regarded as necessaries, food, clothing, shelter, medical attention, an exception is made to protect the interest of the adult who furnished the necessaries. She may not recover on the contract price a loss of bargain measure of money damages. She may, however, recover in quasi-contract for the market value of the necessaries which the minor received under the bargain and has consumed. Minority. What about the defense of mental incapacity? Again, it is a personal defense, rendering voidable the contract obligations of an individual who either permanently or temporarily lacked the mental powers necessary in order to form a contract. Right? If necessaries were the subject matter of the bargain with the mental defective, then we apply the same rule we did to the contracts with minors. There would be a recovery on a theory of quasi-contract for the market value of the necessaries. If the subject matter is not a necessary, no liability at all. Now, it's easy to allow the defense of mental incapacity to a person who has been afflicted by the judgment of God Almighty with some mental impairment. But what about an individual who on normal days is fully possessed of mental faculties, but on the particular day this bargain was formed had those faculties impaired because of some self-induced difficulty with demon rum or worse? Well, here the common law is divided. There are authorities that say that if the mental incapacity is of a temporary nature and was self-induced by the party who's now claiming it, we have no sympathy for that person, and the defense cannot be raised. The dominant and more modern view takes greater umbrage at the other person if that other person knowingly dealt with a person whom he appreciated or should have realized was suffering from the influence of alcohol, drugs, etc. And so the more dominant modern view is, although the incapacity was temporary and self-induced, if the other party knew about it, I may have the defense. Right? Capacity. What about content? Two things to discuss here: illegality, unconscionability. Let's begin with illegality. There are several important points to be made regarding the time in which the subject matter or participation of one of the parties became illegal. All right? If the subject matter became illegal at a time when only the offer was outstanding, all right? For instance, the local church in Davis makes me an offer to be a bingo caller on Saturday night. Before I've accepted the offer, the local district attorney announces a crackdown on religious gambling. Right? If the collision between the law and the bargain comes when the bargain is still executory, when just the offer is outstanding, the offer is revoked, as I told you yesterday, by operation of law. There was just an offer outstanding I'd not yet accepted. I got ahead of myself. What happens if the offer was made and I had accepted it, and the contract was therefore executory, had not yet been performed, when the illegality of the subject matter was announced? Then at common law, I could claim relief from the obligations of the bargain on a theory of objective legal impossibility. Right? Legal impossibility. Under the Uniform Commercial Code, there will be an effort to save a bargain. That should not surprise us at this point. If a contract has been formed and is still executory, and now comes along some supervening governmental regulation declaring the subject matter or the participation of one of the parties to be illegal, then before I can walk away from that agreement claiming objective impossibility, as a merchant, I must determine whether some substitute arrangement could be made, which is both legal and practical. If there is, then I must offer to perform under the modified substitute arrangement. As the other party to this contract, you're not obligated to accept my offer of modification. If you do, then we have modified our agreement in good faith. If you refuse, then I am able to avoid liability on the original terms of the contract by claiming objective legal impossibility. But I must, under the Uniform Commercial Code, make this accommodation effort in a chance to save the bargain. So that has to do with the time. If just the offer is outstanding, it is revoked. If we have an executory contract, we have a problem with objective legal impossibility. The nature of the illegality is also important, because that will determine whether or not there can be any quasi-contractual relief. Right? When we speak of the nature of illegality, we now make a distinction that can be traced all the way back to Thomas Aquinas. It's Aquinas who gave us the terms the law still uses. If the subject matter of the bargain or the participation of one of the parties is intrinsically evil, the classical term malum in se, then the attempted bargain is void. Obviously, if I were to put out a contract on my brother-in-law, as that term is understood in certain circles, with a $10,000 down payment to the torpedo, the subject matter would be intrinsically evil. Any person who'd reached the age of reason could detect the intrinsic wrongfulness merely by consulting personal conscience. You didn't need a law library. In that instance, there is no contract. Further, since I engage in an intrinsically evil arrangement, no court will assist me, even should I attempt to withdraw from the transaction and try to recover my $10,000. The courthouse door is slammed in my face for all purposes. But what if the subject matter is not intrinsically evil, but is merely offensive to some regulatory statute that has been passed for the convenience of society? That is called a malum prohibitum, not intrinsically wrong, wrong only because society has prohibited it. Well, again, there is no contract, because the common law of contracts will never clash with the criminal law, right? Or with regulatory law. But if the subject matter is malum prohibitum, the party who rendered valuable services may well recover in quasi-contract for the market value of those services if she was unaware that the subject matter was regulated and therefore offensive. Right? Now again, to use the classic terms for these modern ideas, if the subject matter is malum prohibitum, no recovery on the contract. Whether there can be a recovery or an adjustment between the parties in quasi-contract depends upon whether or not they are in pari delicto. That means aware of the fact that the subject matter offends the law. If one of the parties is innocent, that means he is not in pari delicto, and he can potentially recover in quasi-contract. Oh, there's one other exception. That exception covers a subject matter which is malum prohibitum, in which the parties are both aware of the offense to the law, so they are in pari delicto. But if one of the parties to that bargain is a member of what is called a protected class, a person for whose protection or benefit society had regulated the subject matter, then although he was aware and thus guilty of knowledge, the party who was a member of the protected class may recover in quasi-contract for the market value of the goods or services. The most obvious example of this, child labor laws. If a 15-year-old child in California goes into the marketplace and seeks to sell his labor, he is engaging in behavior which is malum prohibitum. And even if he is consciously aware that this is illegal, he is a member of a protected class. Therefore, although he cannot recover the wage promised on a theory of contract, he may recover against the employer for the market value of any services which he has performed. Illegality. The other topic under the content of the bargain, unconscionability. Whereby a term of an agreement, one of the parties seeks to avail himself of a privilege which is contrary to public policy. Right? In forming the terms of the bargain, for instance, a seller of an inherently dangerous article attempts to remove, disclaim all warranties, even the implied warranty of merchantability. If the content of the bargain sees one of the parties attempt to insert a term contrary to public policy, that's not illegal, but it is unconscionable. And a reviewing court is capable of one of two reactions to an unconscionable term in a contract. Either it can refuse to have anything to do with that bargain, in which case it will grant no relief at all, or more dramatically, the court can blue pencil the bargain to remove or modify the unconscionable term while enforcing the balance of the exchange against the parties. A court will exercise these inherent equitable powers to police against unconscionability if that is the only way it can prevent what is called oppression and surprise by the dominant party in a transaction. And this is most especially true where at the formation stage of offer and acceptance there was no real opportunity to bargain over the terms of the contract, merely a dominant party who made what we call a contract of adhesion, a take it or leave it proposition, which because of limited ability to satisfy a pressing need, the other party agreed to. If the terms of that resulting bargain offend public policy, it can be policed for unconscionability. Right? And finally, we talk about defenses that have nothing to do with the form or the capacity of the traders or even the content of the bargain. They are all perfectly fine. But the defense arises because society takes umbrage at the tactics used by one of the traders in trying to form the bargain. All right? The first, fraud. fraud. Now, the subject of fraud will be explored extensively in the remedies review, but I want to touch upon the highlights so that you can integrate that into the contract materials. There are three types of fraud known to the common law. Fraud in the factum, also known as real fraud, is assuredly the most base. Fraud in the factum is any contrivance or artifice that prevents the fraud victim from an opportunity to appreciate that a contract is even in contemplation. Therefore, if I were to approach you at an upcoming break and say you've been so exceedingly gracious, but as I return to Davis, I'd love to have a brief memento of our brief time together, would you be so gracious as to autograph this large blank piece of paper down here at the bottom? And being habitually kind, you do so, and later on I fill in the terms of what appears to be a promissory obligation on your part to part with all of your possessions. You would have the defense fraud in the factum. As a victim, you didn't even know that a contract was in contemplation. Fraud in the factum is a real defense. There is no contract. But there's also fraud in the inducement. Fraud in the inducement is a personal defense. In a fraud in the inducement fact pattern, the victim is aware that a contract is in contemplation. His consent to enter the contract, however, is seduced by lies or half-truths. Fraud in the inducement gives the victim an opportunity to assert the personal defense and have his obligations voidable. Most rare is a type of fraud called fraud in the execution. Fraud in the execution sees the victim aware that a contract is being formed. Indeed, his consent is validly obtained. Where the fraud enters the picture is that the bargain is oral, and now the victim trusts the other party to reduce their oral agreement to a formal written expression, which the other party does and then comes back and says, "Here's our deal, sign this paper." And the victim trustingly signs the paper without closely examining it. Later on, it turns out that the party who prepared the writing suffered from selective or creative memory. Now we have a victim of fraud in the execution, and that is also a personal defense. The obligations expressed in this paper are voidable if the victim chooses to assert the defense. What about duress? Duress will also be covered in the remedies review, but let's highlight it. There are two types of duress known to the common law. Duress of the person. These are either mental or physical force directed against the victim, and they always render the consent of the victim voidable. Voidable. So if there is physical or mental force, this is literally the offer you cannot refuse. Your signature on the paper or your brains on the wall. Or your signature on the paper and then you'll see your little girl again. That would be duress of the person. Threats of duress are called menace and are treated by the modern common law as the same as duress. So either the exertion of physical force, I point a gun at you, or the threat that if you do not capitulate, I will have you taken care of by the exterminator, would be physical duress, duress of the person. Always render the obligations of the victim voidable. More subtle is the doctrine of economic duress, sometimes called duress of goods.
Please stop the machine at this point and turn the cassette over for side 2.